Hello viewers, welcome to my channel. I'm Hasham. So now I'm going to start the next topic in business law, that is performance of contract. In the last video, I have explained you in detail regarding the discharge of contract. So this topic, performance of contract, is a part of the last topic, discharge of contract. So in order to understand this video, this topic, you must have the knowledge about discharge of contract. Without watching that video, if you come here, it will be a little bit difficult for you to understand. So I suggest you to go to the playlist of my channel, select the subject business law, select the topic discharge of contract. In that video, I have explained you the meaning of discharge of contract and what are the modes of discharge. So actually 6 modes are there of discharging the contract. That means terminating the relationship, contractual relationship between the parties. So how the contractual relationship of the parties will be terminated, will be finished. The 6 modes I have explained in the last video. The first mode is through performance. By performance, the contractual relations comes to an end. Secondly, by agreement or by consent, the contractual relations can bring to an end. Similarly, third one, impossibility of performance. Third one. Fourth one, lapse of time. Fifth, by operation of law, by breach of contract. So these are the 6 modes of discharging the contract. Out of these 6 modes, the first mode is very important, that is performance. So in this video, I am going to explain you what do you mean by performance of contract and what are the types of performance. I'm going to explain to you. So watch the video till the end, because in examination you may be asked a theory question regarding what do you mean by performance of contract and what are the different types of performance of contract. What is actual performance? What is attempted performance? I'm going to explain. Watch the video till the end. First of all, the meaning of performance of contract. It's very easy. Easily you can remember, easily you can write. When both the parties have completed their obligations, the contractual relationship comes to an end. Both the parties have complied, have fulfilled their contractual obligations. Then the obligations will come to an end. That means the contract is completed, discharged by performing their obligations by both the parties. So the term performance of contract means that both promisor and promisee, that means the offerer and the acceptor, both have completed, have fulfilled their respective obligation. The promisor as well as promisee, both the parties have completed their contractual obligations, fulfilled their contractual obligations. It is called performance of contract. It implies fulfillment of the terms of the contract by the respective parties to the contract. Fulfillment of the terms of the contract. In every contract, there are some terms and both the parties have agreed on the terms. When the terms are complied with, fulfilled, then obligations will come to an end. That is called performance of contract. When both the parties of contract fulfill their obligations under contract, it is said to be performed. So this paragraph I have explained you the meaning of the term performance of contract. Now example, simple example. A visits a stationery shop. A person visits a stationery shop to purchase a calculator. So the shopkeeper has delivered the calculator to Mr. A and Mr. A has paid the price to the shopkeeper. That means both the obligations are completed. A has got the calculator and B has got the price. Consideration is over. The relationship between the buyer and seller is completed. The contractual relationship between the two parties completed between A and shopkeeper. A has purchased the calculator and shopkeeper has sold the calculator. That means the contractual relation comes to an end. It is called performance of contract. That means the contract is discharged by performance. This is the example. Now, the performance are of 2 types. So we divide the performance into 2 types. Actual performance and attempted performance. Now first of all, I am going to explain you about actual performance. See here. When both the parties fulfill their obligations in accordance with the terms and conditions of the contract, it is known as actual performance. Two parties are there, promisor, promisee. Both the parties have fulfilled all the terms and conditions, completed their obligations, contractual obligations, then the relationship will come to an end. That is called actual performance. Promisor has completed his obligation, promisee has completed their obligation. Both the parties completed their obligations respectively. It is called actual performance. Now, it is that type of performance where each party of the contract fulfill their contractual obligations under the contract. Nothing is left. Just now I have given one example. A visits a shop to purchase a calculator, stationery shop to purchase a calculator. A has given the price and B has delivered, the shopkeeper has delivered the calculator. That means both the parties have completed, has satisfied their terms and conditions. They completed their obligations, contractual obligations. The relationship comes to an end. This is called actual performance. After fulfillment of the respective promises, no party remains liable for further performance, and each party is completely discharged from their obligations. Once their obligation is completed, they are not liable for any other performance. Like A has paid the price to the shopkeeper, his obligation is completed. B has delivered the calculator, shopkeeper has delivered the calculator to Mr. A. That means both have completed. That means no further liability on the parts of both the parties, and the relationship comes to an end. Now, this is the most expected and beneficial discharge of contractual relationship. There are different modes of discharging of contract, but the most important, the very first mode of discharging the contract is by performance. The majority of contracts are discharged by performance only. It is beneficial for both the parties. See here, we enter into a number of contracts daily. Daily we enter so many. For example, when we are using our bike, we need petrol. We go to the petrol bunk. So we have purchased the petrol. We have put the petrol in our bike. We have paid the price, contract is over. When we go to purchase grocery, we have purchased the grocery, we have paid the amount, contract is over. So many contracts are there, many examples are there where the actual performance. Contract is discharged by actual performance. So it is the most beneficial discharge of the contractual relationship and will lead to happiest ending of the contractual relationship between the parties. Both the parties are happy. Here, A, in our example, A is in need of calculator. He wants calculator. If he gets calculator, he will be happy. Similarly, the shopkeeper wants to sell the calculator. When he sells the calculator, he will be happy. So both parties are happy. The ending will be happy by using this, by having this actual performance, discharged by actual performance. Here, one and two examples I am going to give you about actual performance. C and D enter into contract that C will sell a computer to D for rupees 25,000. When C delivers the computer and D pays 25,000 to C, the contract is discharged by the performance, just like the previous case. Here C and D, two persons, enter into a contract where C wants to purchase a computer and D is the seller of the computer. The price of the computer is 25,000. C pays 25,000 rupees to D. D delivers the computer to C. Both have completed their obligations. The contract will come to an end. Discharge of contract by actual performance. Finished. One more example I am giving you. M promise to deliver a certain quantity of goods to N on a certain date and on payment of rupees 50,000. The agreement is between M and N. M agrees, promises to deliver certain quantity of goods to N on a certain date at certain place for rupees 50,000. This is the agreement, promise made by M to N. If M dies before delivery, if M dies, expired before delivering the goods to N, then what will happen? Legal representatives of M are liable to complete the contract. Legal representatives of M. So legal representatives of M are bound to deliver the goods to N, and N will be bound to make the payment of 50,000 to the legal representatives of M. So suppose if the promisor dies before delivery of goods, then the legal representatives of the promisor, is bound to deliver the goods to the promisee, and the promisee is bound to pay the price to the legal representative of the deceased. So this explanation is about actual performance. This is the first type of performance. Now second type of performance is attempted performance or tender of performance. Both mean same. You can call it as attempted performance or you can call it as tender of performance. What is this? Now I am going to explain you. So here you have to be careful. This actual performance is very easy to understand, but here you have to put some extra effort in understanding. So what is this attempted performance? Not actual, attempted. When an offer is made by one party to perform his obligation under the contract, but the other party does not accept the performance, it is known as attempted performance. The performance is not completed, half completed. Meaning one person is ready to complete his performance. A and B enter into an agreement that A will deliver some goods to B. Now A is ready to deliver. A has brought the goods to B's place. Now asking, you have to complete your performance. I have completed my performance. Come on, you complete your performance. B says, no, I will not complete my performance. This is called attempted performance. Because one party is ready to complete his obligation, but the other party refuses to complete his obligation. It is called attempted performance. Attempted performance. Now, the offer of performance by a party of his part to the promise is called tender. When one person is ready to complete his part, to complete his promise, it is called his tender. For example, A is ready to complete his promise. So in other words, A is tendering. A is tendering to whom? B. B is not accepting the offer. Already agreement have been made. After making the agreement, all the terms and conditions are there. Here A has to deliver the goods to B. A is ready to deliver, but B is not ready to accept. That is called attempted offer or tender. Now in such a case, it excuses the promisor from further performance, and he does not lose his right under the contract. That is, he is entitled to claim damages. When he is ready, when the promisor is ready to complete his promise, he is having the full right, because he is ready to complete the contract, but the other party is not accepting the performance. In that case, A is having the right to claim damages from B, because B is refusing to accept the performance. B is refusing, whereas A is complying all the terms and conditions. Now, example. With the help of simple example, you can easily understand what do you mean by attempted to performance. S enters into a contract with R. Remember, S, one person, R is another person. S enters into a contract with R to deliver 100 tons of potato at his warehouse on 5th May 2018. So agreement between S and R. S says, I will supply 100 tons of potatoes on 5th May 2018 at his warehouse. Whose warehouse? R's warehouse. R's warehouse. So S is ready to deliver the 100 tons of potatoes to the warehouse of R. S takes the delivery to R's place on the due date during business hours, but R, without conveying any good reason, refuses to accept the delivery. Already agreement has been signed, agreement has been made that S will deliver 100 tons of potatoes to R at his warehouse place. Now, S has completely packed all the goods, all the potatoes, and took this shipment to the place of R during business hour. But R refuses to take the delivery. R refused. It's a tender. It is a tender from the point of view of S, because S has completed his obligation. He took the goods. He took the goods to the place of the promisee, but the promisee refused. Without any valid reason, he is refusing to accept the goods. Now, in the given situation, S has performed his duty created by the contract. S has completed his duty, obligation written in the contract. But the performance performed by S is called attempted performance and is considered equal to performance. And he does not need to perform again, and also not lose any contractual right. Because S has completed his obligation, he is having full contractual right. He has completed his obligation of performance. The default is on the part of R. That means if R refuses, then S will have the right to prosecute, to sue R in a court of law. That is not purchasing, is not accepting the delivery. Already agreement has been made. So it is a tender from the point of view of S. Now, what are the essentials for a valid tender? In examination, you may be asked, very frequently they will ask a question like what is attempted to performance? Attempted performance. What is tender? Tender to performance. This theory question. Apart from that, they will ask you what are the essentials for a valid tender. When the tender will be valid? If the tender is valid, then only the promiser can sue the promisee. Otherwise, if there is a flaw in the tender, the promisee will not pay any damages. So when the tender can be called an effective or valid tender, some conditions. The first condition, unconditional. When promiser is delivering the goods, when the promiser is performing his promise, it should be unconditional. If condition is attached, then tender will be invalid tender. It is not a valid tender. That means we will definitely not accept it. For example, in this case, in the given example, S enters into a contract with R to supply 100 tons of potatoes. Now, at the time of delivery, at the time of completing the performance, S is supplying only 80 kilogram. Instead of 100 kilogram, 80 kilograms only is supplying by S to R. R will refuse it. R will not accept it because you are putting condition. Earlier the agreement is 100 tons of potatoes will be supplied by S to R. Now S is supplying only 80 tons. There is a condition attached. So the tender will not be valid. The tender will not be valid. Now B will have the right to reject. B will have the right to reject because the agreement was 100. He is supplying 80. So first condition is unconditional delivery. Unconditional performance by the promiser. Secondly, should be done at the proper time. If the time is fixed in the agreement, the terms are given regarding the time of supply. At that time only the goods should be supplied by the promiser to the promisee. If no time is specified, reasonable business hours, the delivery should be made, the promise should be conducted during business hours, not odd times. If the delivery is done, if the promise is conducted in an odd time, then definitely promisee will have the right to reject it. So second essential condition given, it should be on reasonable time. Whatever time is specified in the contract, at that time only delivery should be made. Then third one, at proper place. In the contract, in the agreement, the place where the contract should be performed, that will be specified. Where the goods should be delivered, it should be specified. If it is not specified, then definitely it will be at the place of the promisee or at the place of the promiser. Then next one is reasonable opportunity. When the performance is being completed by offerer, that means the promiser, reasonable opportunity should be given to the promisee to inspect the goods, to see that the promise completed by the promiser is according to the agreement or not. Reasonable opportunity should be given to the promisee to inspect the goods, that is according to the agreement or not. If reasonable opportunity is not given, then tender will be invalid. Next one, whole obligation. Whatever obligation is there, completely it should be performed by the promiser. The promiser should not complete part obligation. Partly obligation he should not complete. The promiser should be complete his obligation. Then only the tender will be valid tender. Next one is proper person. That means in the agreement the name of the promisee or his agent is specified. That means the tender should, in order to be valid tender, the goods should be delivered or the promise should be made to the promisee or to his authorized agent. The promise should not be completed to an unauthorized person. Next one is joint promisee. If there is no single promisee but 2-3 joint promises are there, then according to the terms of the agreement, the promise should be completed on behalf of all the promisees, or if any representative promisee is there, then the performance should be done to the respective promisee only, not to an unauthorized person. Last one, proper form and manner. That means if in the contract agreement some proper form or manner of completing their obligation is specified, then definitely the offer should be according to the proper format, according to the proper manner. If it is not according to the proper manner, then the promisee will have the right to reject or refuse the contract. So these are the essentials for valid tender. Valid tender. If all these conditions are satisfied, then the promiser will have the right to prosecute, to claim damages from the promisee for not completing his obligation. That's all. So this is the end of this topic. In this video, I have explained you regarding the meaning of performance of contract and what are the types of contract, that is actual performance and attempted performance. So the next video, I'll continue some more topics, then practical problems on this performance of contract I'll give in the next video. So watch the next video also to get the complete command on this performance of contract.